Good morning, everyone. So it's been a while since I have covered the Harco case against Wayfarer. There's been a few things that have happened. I think I last covered Wayfarer's motion to dismiss, which I will put a link to that video in case you want to catch up. I'll put that link in the video description, so you can go and check that out if you want, if you haven't already. Just to recap, though, because I'll do that anyway for you. So obviously, Harco filed this. They're the insurance company for Wayfarer. I think they Wayfarer are attempting to invoke their insurance policy to cover their legal fees in the Lively case, and Harco have turned around and said no, because they're saying, well, the fact that Wayfarer's complaint against Lively, the Wayfarer v Lively complaint, was dismissed in June. They're trying to say, well, that proves that they've got no case, blah blah blah. And Wayfarer have actually filed they filed a motion to dismiss, but it's a motion to dismiss or stay. So what that means is Wayfarer saying to the judge, look, they shouldn't even be bringing this. And they're saying, well, Wayfarer are still involved in a lawsuit, against Lively, and they are defending themselves against her allegations. And that decision, the outcome of that lawsuit, has not actually been decided. So, although Wayfarer's claims against Lively were kind of thrown out, the claims that they have against Lively did not actually prove that there was, sexual harassment or a smear campaign. So they were Wayfarer's claims against her for, breach of contract and, false light and defamation, etc., etc. But the reason they were bringing a lawsuit against Lively was not specifically because, Lively was claiming sexual harassment. Wayfarer is alleging, civil extortion. Well, that is, the fact that that claim has been thrown out by Judge Lyman does not prove that Lively's actually been telling the truth about her own claims, her sexual harassment, and the smear campaign. The truth of that lawsuit is still ongoing. We have not had a trial, and Wayfarer is saying, well, hold on a minute. If because Harco are going for a declaratory judgment here. And they're basically saying to the judge, look, without a trial, can you please, find in favour of us? And Wayfarer is saying, no, there's still an ongoing trial. We haven't had the trial. We have not been found liable for anything. We are still defending this case. And, obviously that case is currently sitting with Judge Lyman. There's a hearing due on the 22nd of January to discuss, amongst other things, the motion for judgment on the pleadings and the motion for summary judgment. Wayfarer is saying, well, if you decide now and find in favour of Harco, well, what if we actually win our case? That's going to give opposing verdicts, which I think is very fair and very reasonable. The other thing they're saying is, well, New York is not the right forum. They're saying, no, if they want to bring this, take it to California. That's where we are. That's where the harm was, etc., etc. So, and they basically said to the judge, look, if you're not prepared to dismiss this case right now, can you please stay the decision? So basically, just hold, do nothing. And we saw that kind of happen, like when in the main case, when the New York Times, they filed a motion to dismiss. They then didn't want to have discovery conducted upon them whilst there was a pending motion to dismiss. So they requested a stay of discovery, which Judge Lyman granted, and then they were dismissed, and New York Times effectively got out of the case without ever being subjected to discovery. So Wayfarer is saying, look, please dismiss it for all these really rather good reasons, or, stay the case and don't make a decision. Hold off until, this case has been decided in the main action. And I thought they were all incredibly good reasons. I was quite impressed with the motion to dismiss. We have now got Harco's response. Okay, let's look at this. So obviously we're going to skip past all this. And we start here. Plaintiff Harco National Insurance Company respectfully submits this memorandum of law in opposition to the motion to dismiss or stay this action, filed by the defendants, Wayfarer Studios, and that includes, it ends with us movie, Justin Baldoni, Jamie Heath, and Steve Sarowitz. So that's all the Wayfarer defendants in the main case, but obviously the PR girls and the company. Harco filed this insurance coverage action, just make this bigger, in good faith to obtain a timely and definitive judicial determination of its coverage obligations arising from an underlying lawsuit. So that's the Lively lawsuit. A case already pending before this court and moving forward quickly pursuant to this court's scheduling orders. Such early insurance coverage determinations allow insurers, insureds, and all of the parties to an underlying litigation to align their conduct, as well as their litigation and settlement posture, given the defined contractual and economic obligations. Let me just check something a minute. Yeah, so this case is also before Judge Lyman, just to remind everyone. Okay. Disputes such as this are quintessential cases for U.S. district courts to issue declaratory judgments. The Wayfarer party's motion rests on a fundamental misapplication of the Brilhart-Wilton abstention doctrine. It overlooks key procedural and factual differences between this and the later filed California coverage action involving different insurers and different insurance policies. Harco respectfully submits that proper application of the Brilhart-Wilton factors to the facts and posture of this case does not support dismissal or a stay. Unlike the cases cited in the motion, there is no pending parallel proceeding involving Harco, the insurance policies Harco issued to Wayfarer, or the facts relevant to Harco's coverage position with respect to the Lively lawsuit. Rather, the California lawsuit concerns different insurers, different insurance policies with different terms and different coverage issues, such that it cannot afford complete relief between Harco and the Wayfarer parties. Further, abstention by this court in this action would not promote efficiency. It would instead multiply proceedings, delay resolution of this dispute, and create the very inefficiency that the Declaratory Judgment Act seeks to avoid. As detailed below, the relevant Brilhart-Wilton factors either weigh against abstention or are neutral. The Wayfarer parties focus on just 3 factors, i.e., whether California provides a more convenient or proper forum, whether Harco engaged in improper forum shopping, and whether abstention is warranted because this action involves California insurance law, are neither controlling nor compelling. Rather, 2 of those factors, convenience and forum shopping, actually favor this court retaining this case, as do all other factors their brief does not even address. This court, which is already overseeing the Lively lawsuit, is the best equipped forum to ensure consistent adjudication of the coverage questions in this action tied to the pleadings and evidence in that ongoing case. This court has already recognized this by accepting this action as related to the Lively lawsuit and in its ruling denying the Wayfarer party's motion to quash Ms. Lively's subpoena for Harco's insurance documents. Moreover, Harco is statutorily entitled to a federal court forum, whether here or in California. As to choice of law and forum shopping, this court regularly applies California and other states' laws to disputes before it when appropriate, and Harco filed this action only after denying coverage and waiting more than 30 days with no indication that litigation was imminent. In short, this court should put no weight on the Wayfarer party's suggestion that the court where the underlying case is pending is somehow more convenient, much less appropriate. At bottom, under the Declaratory Judgment Act, this court routinely decides insurance disputes like this one between diverse parties, and in this case, the principles of efficiency and fairness all favor retention of jurisdiction. Okay. Statement of the case. The lively lawsuit is commenced and the Wayfarer parties begin to defend. As the Wayfarer party's motion acknowledges, this court is very familiar with the lively lawsuit, which was filed in this court on December 31st, 2024, and served on the Wayfarer parties within the first 10 days of January 2025. Counsel for these Wayfarer parties filed appearances shortly thereafter on January 22nd, 2025, and on January 24th, 2025, Wayfarer and It Ends With Us Movies filed answers to the complaint. Ms. Lively filed an amended complaint on February 18th, 2025, and the Wayfarer parties filed their answers to the amended complaint on March 20th, 2025. This court has set the Lively lawsuit for trial to commence on March 9th, 2026. That's obviously been moved to, I think it's the 18th of May off the top of my head. I don't have the date in front of me. It's certainly in May. I'm pretty sure it's around the 18th, the middle of May. But at the time of this was filed, which was at the end of November, that date was still the March date. The Harco policies. As detailed in Harco's complaints in this action, Harco issued 2 separate management liability policies to Wayfarer as the named insured. One effective from July 15th, 2023 to July 15th, 2024. So that's the 2023 policy. And then one effective from July 15th, 2024 to July 15th, 2025, and that's the 2024 policy. Each policy was issued in reliance on applications in which the Wayfarer parties made certain representations and warranties. Subject to all of their terms, conditions, limitations, and exclusions, each of the policies provide insurance coverage, including directors' and officers' liability and employment practices liability. Each of these coverages are triggered by claims first made against insureds and reported to Harco pursuant to the terms of the policies, unless coverage is precluded by any exclusions of the policy. Okay. Nearly 4 months after receiving service of the Lively lawsuit, the Wayfarer parties submit notice to Harco and request a defence by Harco. On April 25th, 2025, A, nearly 4 months after the Wayfarer parties received service of the Lively lawsuit and hired counsel to represent them. B, 3 months after Wayfarer and It Ends With Us movie answered the complaint. C, more than 2 months after Miss Lively filed an amended complaint. And D, over 1 month after the Wayfarer parties filed answers to the amended complaint. The Wayfarer parties first provided notice to Harco of the amended complaint in the Lively lawsuit as a new loss and asked Harco to provide them with a defence in that action. By letter dated June 20th, 2025, Harco disclaimed coverage for the Lively lawsuit. Later that same day, by email, a New York-based attorney responded stating that the Wayfarer parties disagreed with Harco's position and would be providing a substantive response shortly explaining why they believed Harco's position was incorrect and to ask that the denial be withdrawn. A month then passed without arrival of the promised substantive explanation or any further communication from the Wayfarer parties' counsel as to why the putative insureds believe Harco's denial was incorrect. Meanwhile, the lively lawsuit was proceeding apace, with deadlines set for all parties' document production to be completed by July 25th, 2025, and all depositions and fact discovery to be completed by September 30th, 2025, and trial set for March 9th, 2026. Of course, if, as Harco maintains, its policies do not provide coverage for the defence or resolution of the lively lawsuit, then the progress of that litigation does not matter to Harco. But if, as the coverage counsel for Wayfarer parties asserted in the email on June 20th, 2025, coverage is potentially available, then Harco's is prejudiced by the lack of the promised information, including the loss of any potential opportunities to limit its exposure. Okay. I do think, if that's all correct, those timelines, the delays in Wayfarer notifying Harco, I do think that may cause Wayfarer a problem, in all honesty, because if you're expecting insurance companies to indemnify you, then they need to, be able to approve lawyers, the fees, they have to be able to, be kept informed and updated as to how much money is being spent, what it's being spent on. And if I do think that Wayfarer have come late into the game in notifying Harco. So that may be an issue. It may not be, but it is something that, do I think that means Harco shouldn't have any liability whatsoever? No, that's not what I'm saying. I'm just saying I think that there may be a problem. Do I think it needs this lawsuit? Probably not. Okay, so let's continue. Faced with this uncertainty and lack of further communication, on July 21st, 2025, Harco filed its complaint in this action for a declaratory judgment pursuant to Federal Rules of Civil Procedure, Rule 57, and the Declaratory Judgment Act 28. Harco also filed a statement of relatedness to the lively lawsuit, noting that the Wayfarer parties are also defendants in the lively lawsuit, and the facts alleged and admitted in the lively lawsuit are directly relevant to Harco's coverage defences. Per the court's docket for this case, on July 23rd, 2025, this court accepted Harco's action as related to the lively lawsuit. Just one day after this action was instituted, the Wayfarer parties sent to Harco their long-promised letter responding to Harco's denial. In a footnote, this letter acknowledges that the Wayfarer parties were aware of the filing of this action. In addition, the letter makes 2 points which undercut Wayfarer's position in the present motion. 1. It recognizes that New York and California courts apply the same standard for evaluating an insurer's duty to defend. And 2, it asserts that Harco's other insurance defense is irrelevant because, as a general rule, insurance policies should be interpreted as if no other insurance is available. On July 30th, 2025, the Wayfarer Parties Council rejected Harco's counsel's request that they accept service of this action despite having identified themselves as the Wayfarer Parties Coverage Council in response to Harco's June 20th, 2025 coverage denial letter. Harco then initiated service on the Wayfarer parties, copying their counsel as a courtesy. Wayfarer's California lawsuit. Also on July 30th, 2025, the same day that Harco asked the Wayfarer parties to accept service of this action, and unbeknownst to Harco, the Wayfarer parties filed a separate coverage action in the California Superior Court for the County of Los Angeles against 3 insurers, not including Harco. The complaint in the California lawsuit alleges that each of the insurer defendants issued insurance policies providing coverage to either Wayfarer or It Ends With Us movie, which required them to defend the lively lawsuit, and that each denied coverage based on the particular terms, conditions, and exclusions of their respective policies. This complaint also asserts separate causes of action against each of the other insurers, disputing the basis for each of the other insurers' separate denials of coverage based on the specific terms of their respective insurance policies, each of which are materially different than Harco's basis for its denial of coverage under the terms of its policies. The California lawsuit filed after Harco properly commenced this action in this court appears to have been an effort by the Wayfarer parties to forum shop out of this court. Indeed, the Wayfarer parties took steps to delay this action in favour of their California lawsuit. And what I will say to that is, after the way Judge Lyman has ruled against them so many times in favour of libel, who can blame them? As noted above, on July 30th, 2025, the same day that the Wayfarer parties filed the California lawsuit, they declined to accept service of Harco's action. Then, approximately 20 days later, after filing and serving the California lawsuit, the Wayfarer parties changed their position and agreed to accept service of this action on the condition that service be deemed effective on August 25th, 2025. This condition effectively extended the Wayfarer defendants' time to respond to Harco's complaint until October 24th, 2025, allowing the California lawsuit to advance slightly ahead of this action. Although the Wayfarer party's California lawsuit is the basis for the present motion, that complaint is not in any way parallel to this action. Rather, Harco is not a party to that action, and the other insurers denied coverage for the libel lawsuit based on their respective policies, distinct coverage terms, giving rise to distinct contractual and factual issues. Specifically, one of the other insurers named in the California lawsuit, New York Marine and General Insurance Company, is alleged to have issued 3 separate commercial general liability insurance policies to Enter Thus Movie, providing occurrence-based coverage during policy periods effective from, respectively, February 21st, 2023 to May 30th, 2024, May 30th, 2024 to August 31st, 2024, and August 31st, 2024 to August 31st, 2025. These policies allegedly provide coverage for bodily injury and property damage and for personal and advertising injury as defined therein. These policies thus cover different risks than those covered by Harco's claims made and reported D&O and EPL coverages, and apply based on different triggers, occurrence versus claims made, during different time periods. Another of the other insurers named in the California lawsuit, QBE Insurance Corporation, allegedly issued a single policy to Enter Thus Movie as the named insured, with Wayfarer as an additional assured, apparently only for specified types of claims. Unlike the Harco policies, the QBE policy appears to provide coverage for certain types of claims made during a 3-year policy period from May 9th, 2023 to May 9th, 2026. And unlike the Harco policies, this policy allegedly applies to claims arising out of specifically defined media activities. The other insurer named as defendants, certain underwriters at Lloyd's of London that is, allegedly issued a single policy to Wayfarer, providing coverage for a policy period from December 6, 2024 to December 6, 2025. Again, unlike the Harco policies, underwriter's policy allegedly provides coverage for multimedia liability and advertising injury, as well as professional liability and breach of contract, as each of those terms are defined in underwriter's policy, and is apparently limited to claims arising from the Man Enough podcast or its related content. In short, the California lawsuit is addressed to coverage determinations by other insurers based on policy terms wholly distinct from the terms of the Harco policies and therefore will not resolve the coverage dispute in this action. Okay, so that's really interesting. Obviously, now we have more context. And I gotta say, that's a good argument. Wayfarer have filed a reply, so we will look at that too. But if this is an entirely different lawsuit, that Wayfarer is saying, "Oh, hold on, we've got another lawsuit already going on in California. Wait for that to finish." But the lawsuit involves different insurers on different terms, etc., and it's not actually the same, then that could be problematic. Okay, so we have the argument. The Wayfarer party's motion asks this court to abstain from hearing Harco's properly filed action based on the Brilhart-Wilton abstention doctrine, which is derived from the Supreme Court's decisions in Brilhart against Excess Insurance Company of America and Wilton against Seven Falls Company. As noted by the Second Circuit, this standard applies when a parallel proceeding is pending involving the very same parties, and it otherwise vests the district court with broad discretion to determine whether and when to entertain an action. In this case, proper analysis of the factors under Brilhart-Wilton and its progeny weigh heavily against abstention by this court. Okay. Application of the Brilhart-Wilton doctrine is improper where there is no parallel action between the same parties. Okay. The Brilhart-Wilton doctrine does not apply here because it is triggered only when there are duplicative and parallel actions pending between the same parties. As the Second Circuit has also explained, federal and state proceedings are concurrent or parallel for abstention purposes when the two proceedings are essentially the same. That is, there is an identity of parties and the issues and relief sought are the same. Indeed, the vast majority of the abstention rulings cited in the motion involve a pending parallel action between the same parties. So, and then it goes on to list a load of cases, which I'm not going to go through. Okay. Here, in contrast, there is no pending parallel litigation between Harco and the Wayfarer parties. Rather, this foundational requirement is glossed over by the Wayfarer parties' attempt to characterize the California lawsuit as raising similar questions as raised by this action and their suggestion that Harco could have been named in that action. Such hypotheticals do not render two proceedings parallel. The Wayfarer party's contention that they will seek to add Harco to the California lawsuit if this case is dismissed does not alter the analysis of whether the two proceedings are currently parallel. Although Harco has not seen the other insurers' policies or coverage positions, material differences are plain on the face of the complaint in the California lawsuit. For example, as detailed in Harco's complaint, the Harco policies provide coverage for certain types of D&O and EPL claims, subject to the terms, conditions, limitations, exclusions, and the representations and warranties provided in the applications for the Harco policies. In contrast, as reflected in the allegations of the California lawsuit complaint, and as detailed above, the other insurers' policies include materially different terms and coverage triggers, including. So they're going through each of the three insurance companies. So the MYM, that's the New York Maritime, allegedly issued CGL policies which provide coverage for damages because of a bodily injury, property damage, or personal and advertising injury caused by an occurrence, as those terms are defined, and which occurs during the effective periods of those policies. QBE allegedly issued a policy which provides coverage for loss on account of a claim based upon scheduled media and media activities that occur during the policy period. And then this is the Lloyd's of London. Underwriters allegedly issued a policy which provides coverage for multimedia liability and advertising injury, as well as a professional liability, and breach a contract. This policy apparently provides coverage for the insured's business activities, which are defined to mean the Man Enough podcast and its related content. Okay. Whether coverage exists under those very different policies with very different terms raises very different contractual issues than those presented in this action. Further, wholly different factual and contractual issues are also raised as to whether Harco and the other insurers breached their respective duties to investigate coverage for their insureds or to defend or indemnify them in the lively lawsuit, which are based on each policy's respective terms, conditions, limitations, and exclusions. My voice is now starting to go already. In addition, as the California lawsuit does not include Harco as a defendant and does not address the basis for the coverage dispute under the Harco policies, any ruling in that action will neither resolve Harco's distant contractual obligations under the terms of the very different Harco policies, nor will it resolve the fact relevant to Harco's coverage denial, such as the nature of the information provided to Harco by Wayfarer in the warranty and applications for the Harco policies. Thus, unlike in Brilhart-Wilton and their progeny, there is no potential for interference by this federal court on the issues presented by the California lawsuit, which is a really good point. For these reasons, and because abstention under Brilhart-Wilton is appropriate only when a truly parallel proceeding is pending between the same parties involving the same issues, the doctrine has no application here, and the motion should be denied for this reason alone. The court should neither stay nor dismiss the action because the Brilhart-Wilton factors weigh against abstention. Although, as discussed above, this action and the California lawsuit are not parallel proceedings, should the court find it appropriate to consider additional Brilhart-Wilton factors, abstention is not warranted because the relevant factors weigh against it. The motion states that factors to be considered when evaluating whether an action should be dismissed or stayed under Brilhart-Wilton include 1. The scope of the pending state proceeding and the nature of the defences available there. 2. Whether the claims of all parties in interest can satisfactorily be adjudicated in that proceeding. 3. Whether all necessary parties have been joined. 4. Whether such parties are amenable to process in that proceeding. 5. Avoiding duplicative proceedings. 6. Avoiding forum shopping. 7. The relative convenience of the fora. 8. The order of the filing. And 9. Choice of law. As the motion and the case law recognizes the determination of whether to dismiss or stay a federal court action in favor of a state court action is within the sound discretion of the district court, and that the relevant factors need not be all weighed equally as their relevance varies with the circumstances. Here, the relevant factors weigh decisively against abstention. Okay. The scope of the pending state proceeding and the nature of the defences available there weigh heavily against abstention. As discussed above, this action and the California lawsuit involve different parties, different insurance policies, covering different risks and different defences tied to those different policies. This factor weighs heavily in favour of the court retaining jurisdiction of this case. Okay. Whether the claims of all parties in interest can satisfactorily be adjudicated in the state court proceeding. As currently constituted, the answer to this factor is a firm no. Important here is the fact that the Wayfarer parties, as plaintiffs in the California lawsuit, did not name Harco as a defendant, and they do not argue here that Harco is a necessary or indispensable party for a full adjudication of the issues in the California litigation. While it may be possible for the Wayfarer parties to file new belated claims adding Harco to the California lawsuit, any such potential future claims would be based on the Harco policies and Harco conduct, not the other insurers' policies or conduct currently at issue in the California lawsuit. Harco's coverage dispute is therefore not within the scope of the pending action, contrary to the Wayfarer party's assertion, and will not be adjudicated in that proceeding. Further, the California lawsuit has already moved ahead of this action with answers and defenses filed by the other insurers. I will have to look at that lawsuit. It's not so easy for me to get hold of state legal filings as it is to the federal, but I will see if I can get hold of them and see where we are. Okay. Conversely, the claims, rights, and defenses of the parties in the California lawsuit can effectively be adjudicated in that action without Harco, just as the issues presented here can be fully and fairly adjudicated without the participation of the other insurers. Indeed, as quoted above, Wayfarer's Counsel's July 22nd, 2025 letter to Harco's counsel argues that the possibility of insurance coverage from the other insurers is generally irrelevant to whether coverage exists under a given policy. As such, this factor also weighs heavily against abstention in this case. All necessary parties to Harco's action have been joined, and Harco is not a necessary party to the California lawsuit. See discussion of number 2 above. In addition, under Federal Rules of Civil Procedure Rule 19, parties are necessary only if, in their absence, the court cannot accord complete relief among existing parties, or they hold that an interest relating to the subject of the action and is so situated that disposing of the action in the person's absence may, 1, as a practical matter, impair or impede the person's ability to protect the interest, or 2, leave an existing party subject to a substantial risk of incurring double, multiple, or otherwise inconsistent obligations because of the interest. Again, the motion does not argue that necessary parties are absent in this case, and manifestly none of the conditions of Rule 19 are present here. That Harco is amenable to process in California is of no weight. Although Harco is amenable to service in California, this factor is entitled to no weight here. This factor focuses on whether all necessary parties can be brought before a particular court. Here, the putative insureds do not and cannot object to proceeding before this court, as they are already litigating before this court in the lively lawsuit. Okay. Avoiding duplicative or piecemeal litigation. Duplicative litigation only arises when two substantially identical lawsuits proceed at the same time. The California lawsuit and this case are far from substantially identical. As detailed above, the California lawsuit involves different insurers, different policies, and different coverage issues. The Wayfarer party's reliance on Colorado River Water Conservation District against United States to argue that this case could result in piecemeal litigation misreads that decision. The Wayfarer parties quote Colorado River's reference to avoidance of piecemeal litigation as though the mere existence of similar state and federal actions automatically warrants abstention. However, the Supreme Court's concern in Colorado River was far narrower. Abstention was proper there only because Congress, through the McCarran Amendment, had expressly favored unified state adjudication of water rights claims within a comprehensive state system. The court emphasized that this clear federal policy supported abstention and held that the mere potential for conflict in the results of adjudication does not, without more, warrant staying the exercise of federal jurisdiction. No comparable federal policy or unified state system exists here, and the mere possibility that a future proceeding might be asserted raising parallel issues does not suffice to strip a federal court of its properly invoked jurisdiction. Rather, this case involves a private insurance contract, and this court's diversity jurisdiction, which was properly invoked, is not challenged. Moreover, even if Wayfarer intends to assert affirmative defences or counterclaims against Harco in this action for recovery of defence costs and for bad faith and punitive damages, as it asserts against the other insurance in the California lawsuit, those defences/claims will necessarily turn on the specific terms of the Harco policies and Harco's conduct in connection with its coverage determination. Accordingly, permitting this case to proceed will not create duplicative or piecemeal litigation, and this factor does not favour abstention. Harco did not engage in improper forum shopping. The Wayfarer party's motion asserts that Harco engaged in forum shopping, but the circumstances demonstrate otherwise. The forum shopping here is by the Wayfarer parties, not Harco, as they filed a later separate coverage action in California and now seek to use that filing to divest this court of jurisdiction properly invoked by Harco. The Wayfarer parties further assert that Harco raced to the courthouse to prevent the Wayfarer parties from their preferred forum. Contrary to these arguments, the facts show that Harco filed this action only after issuing its coverage determination, being summarily told that its position was wrong, and a substantive explanation would follow, and receiving no further or substantive response for a month. Harco also did not receive any indication from the Wayfarer parties, formal or otherwise, that the Wayfarer parties were planning to file suit against Harco. Instead, Harco properly filed this action under the DJA for precisely the purpose it was designed to serve, i.e., to avoid accrual of avoidable damages to one not certain of his rights and to afford him an early adjudication without waiting until his adversary should see fit to begin suit after damage has accrued. Harco's filing is plainly consistent with the DJA's intended function to obtain a prompt resolution of its coverage obligations for litigation already pending in this district, not a tactical race to the courthouse. The cases cited in the motion are readily distinguishable because they involve clear evidence of tactical anticipatory filings in response to express threats of litigation. Here, in contrast, for all Harco knew, the Wayfarer parties had decided to postpone resolution of their disagreement with Harco's coverage position until after the resolution of the Lively lawsuit. Given the extensive public media attention on the Lively lawsuit, Harco had no reason to believe the Wayfarer parties intended to address the coverage dispute promptly, and had every reason to believe that the Wayfarer parties were content to sit on their hands pending resolution of the Lively lawsuit. In short, rather than forum shopping, Harco's filing exemplifies the proper use of the DJA, which exists to allow a party facing uncertainty about its legal obligations to seek timely judicial resolution rather than remain bound by its adversary's choice of when and where to litigate. Factor 6, forum shopping, therefore strongly favours Harco, not the Wayfarer parties. Okay. The relative convenience of the fora weighs in favour of proceeding in this court. The underlying Lively lawsuit is already before this court, and this court has already expressly recognised the relationship between the facts at issue in the Lively lawsuit and Harco's coverage position. The Wayfarer parties are no more inconvenienced by proceeding with this action in this court than they are in proceeding with the Lively lawsuit. So any suggestion of inconvenience for the Wayfarer parties is entirely hollow and unpersuasive. Further, as Harco is incorporated in North Carolina and has its principal place of business in Raleigh, North Carolina, New York is relatively more convenient than California. And while the Wayfarer parties argue that some witnesses are located in California, that point carries little weight. The location of witnesses is not a significant factor here, and multiple relevant witnesses, including Miss Lively, she's going to be a witness to this, are present in New York. Miss Lively's testimony is directly relevant to when and whether the Wayfarer parties were aware of her complaints of misconduct on the set. The Wayfarer party's assertion that proceeding with this action separate from the California lawsuit will require duplicative document productions similarly carries very little weight. While the Wayfarer parties may need to produce overlapping documents in both actions, they will have to produce those documents to Harco and each of the other insurers regardless of the forum. The Wayfarer parties will also have to produce documents to each insurer relevant to the application for that insurer's policy and the specific coverage terms of that policy. In other words, proceeding with separate actions will not increase the burden of document productions. Separate document productions will be required because of differences in the terms of each insurer's policies and the information requested and submitted in the applications for those policies to the extent relevant. As the court explained in Ryan against Volpone Stamp Company, although the state court was equally capable of adjudicating the dispute, there were no special or unique circumstances that justified dismissing this action in deference to the state proceeding. The same is true here. The order of filing favours this court exercising jurisdiction. It is undisputed that this action was filed first. This factor weighs in favour of denying the motion. Courts have long held that, absent strong countervailing considerations, the first filed case is the one that should proceed. This result is especially appropriate here, as there is, in fact, no later filed action between Harco and the Wayfarer parties, and as the other Brilhart-Wilton factors favour this court's exercise of jurisdiction. Notably, even the Wayfarer parties recognise that this factor favours Harco, so rather than disputing this point, they cite Jen Raines for the proposition that order of filing is of no importance if the filings are just a few weeks apart. Even if that were true, the factor still does not weigh in their favour. It is at best neutral. In any event, Jen Raines is readily distinguishable here as noted above. Noting that abstention was appropriate as the amount of policy coverage in a particular period, the layer of coverage of the particular excess policy, and the extent to which the underlying primary and excess coverage has been or is likely to be exhausted, would be addressed only in the parallel state litigation, and the district court's failure to give weight to the order of filing was not an abuse of discretion because only a few weeks separated the filings. Right. Sorry, excuse me. Right. Choice of law considerations do not support abstention. The Wayfarer parties argue that this factor weighs in their favour because this case does not involve any questions of federal law, and because California has a particular interest in ensuring the proper application of its insurance laws. In support of this argument, they cite Intercontinental Planning Limited against Daystrom Inc. and WM Pasalaka Buildings Inc. against Resnick Developers South Inc. This argument is a red herring, as Daystrom and Pasalaka do not concern abstention. They address only choice of law principles. Nothing in those cases or any other authority cited by the Wayfarer party suggests that a state court is inherently better suited than a federal court exercising diversity jurisdiction to adjudicate a private insurance coverage dispute. In any event, choice of law factors do not weigh in favour of abstention here because federal courts, including this court, routinely and effectively apply the laws of other jurisdictions. particularly where, as here, the case presents straightforward state law issues and there are no parallel proceedings underway. And there's some judgments here. I won't go through all of that. Moreover, as noted above, the Wayfarer parties themselves in their July 22nd, 2025 letter assert that New York and California follow the same legal principles on key issues, such as the scope of duty to defend. If the relevant law is the same, then there is no conflict requiring deference to a California court, and this factor carries no weight in favor of abstention. By asserting that federal courts should decline jurisdiction whenever an insurer's declaratory judgment action raises state law insurance issues, the Wayfarer parties are implicitly arguing that diversity jurisdiction should never be exercised in insurance coverage disputes. This would effectively and improperly nullify diversity jurisdiction for an entire class of cases Congress expressly placed squarely within the bounds of federal jurisdiction and which are regularly addressed by federal courts. With this court's familiarity with the facts and parties in the lively lawsuit already pending before this court is the proper and most efficient forum to resolve Harco's coverage obligations in a coordinated manner. Further, because no duplicative parallel state action exists between Harco and the Wayfarer parties, and because this case is soundly within the court's diversity jurisdiction, the absence of a federal question carries no weight in favor of abstention. For the foregoing reasons, the Wayfarer parties' motions to dismiss or stay should be denied in its entirety, and this court should neither dismiss nor stay this action. Okay. My impression, obviously Wayfarer have responded, so we're going to go and check that out next in the video. Next video I do, which will be uploaded later today. But, this is a very good, well-argued filing from Harco. I'm not going to say it's not, it is. But I want to see how Wayfarer respond to it. Because Wayfarer's motion to dismiss or stay was actually very good. This is also a good response, and if some of it's true, then yeah, Wayfarer probably won't win this one. At least with getting it moved, in terms of getting it dismissed or getting it stayed, they may not win. That does not mean that they will lose the declaratory judgment. It's just this motion in particular we're looking at. So I will be back, in a couple of hours. I will with the next video, which will be Wayfarer's reply to this, which will be shorter. I think there was an additional filing then. After that, there was I think Harco filed. I'm just checking, sorry. Yes, so Harco then filed a motion seeking leave to file a SIR reply. So this was all briefed. Wayfarer filed their motion to dismiss or stay. We've just done the opposition to that, Harco's opposition. Wayfarer then filed their reply. And then Harco filed a letter seeking to file a SIR reply, so an additional surplus reply. And Wayfarer have responded to oppose them filing their SIR reply. So there will be another 3 videos out today, which will be considerably shorter. So we'll do Wayfarer's response to this opposition. Then we'll do Harco's motion seeking leave to file the SIR reply, and then we'll do Wayfarer's opposition to that request to file a SIR reply. So that's what my day today will look like. Then I'll be caught up with Harco. All right, I will be back later.